So in today's video, we're discussing the appeal that has been filed by the Senate against Senator Natasha Akpoti Uduaghan. You all recall that judgment was given in the matter that Senator Natasha Akpoti Uduaghan took to the Federal High Court. Honorable Justice Binta Nyako gave judgment not long ago, and the Senate has appealed against that judgment. You can see here, it's headed in the Court of Appeal of Nigeria, Abuja Division. You can see the parties here. President of the Senate of the Federal Republic of Nigeria is the person that is the appellant, and Senator Natasha Akpoti Uduaghan is the principal respondent in this matter. You can see here that the suit was filed, the appeal was filed on 14th July 2025 at the Federal High Court. That's the procedure. When you want to appeal, you file your notice of appeal at the lower court, and the lower court will now transmit what you have filed together with other documents to the higher court, in this case, the Court of Appeal. So, you see here, it is titled Notice of Cross Appeal. This is very significant, Notice of Cross Appeal. The implication of this is that there is already an appeal before the courts, right? Which means Senator Natasha Akpoti Uduaghan has already gone to the same court appealing against the same judgment. So what the Senate is doing here, a cross appeal means there is an appeal here, right? You now carry your own appeal and cross it here. So you know the normal cross. You carry your own, cross it here, and that makes it a cross appeal. Now, it's basically against the judgment of Honorable Justice Binta Nyako that was filed, that was delivered on 4th July. And the cross appeal is not against the entire judgment, which means the Senate has accepted part of the judgment and has disagreed with part of the judgment. And that is why the appeal is against part of the judgment. Basically, the preliminary objection that the court dismissed, the preliminary objection was filed by the Senate. So the court dismissed it, and the Senate is now saying, no, you should not have dismissed that preliminary objection. And the second part is that part of the lower court that talked about the period of suspension, and the Senate has gone to court against that. Now, notice of appeal, you must have grounds of appeal. It is broken into grounds. So in this notice of appeal, notice of cross appeal, you have 11 grounds of appeal. Grounds of appeal simply means areas of disagreement, areas that you are not comfortable with. So the Senate is not comfortable with 11 areas, 11 grounds of appeal. Now, ground 1 says that the learned trial judge erred in law and occasioned a gross miscarriage of justice when it assumed jurisdiction to determine the subject matter of Senator Natasha Akpoti Uduaghan suit. Particulars of error have been given here, and I will explain. What the Senate is basically saying by this ground 1 is that Natasha went to the Federal High Court to complain against her privileges as a senator, her rights and privileges as a senator. And the Senate in this appeal is saying that the Federal High Court did not have jurisdiction to entertain a matter relating to privileges of a senator. Why? Because you see it here by section 251 of the Constitution, the powers of the Federal High Court have been clearly stated. Federal High Court is to deal with issues of currency, issues of aviation, issues of firearms, fundamental rights, and all that. The jurisdiction of the Federal High Court have been clearly circumscribed in section 51 of the Constitution. And the Senate, by this ground 1, is saying that Senator Natasha Akpoti Uduaghan's issue had to do with her rights and privileges as a senator, and therefore the Federal High Court does not have jurisdiction under section 251 of the Constitution to have entertained it, and for that reason the Senate says that the Court of Appeal should set aside the judgment of the lower court for lack of jurisdiction. Ground number 2, the lower court erred in law when it held that the first respondent, that is Senator Natasha Akpoti Uduaghan's matter, was justiciable against the Senate President in contravention of the explicit provision of Section 1 of the Legislative Houses and Powers and Privileges Act. Now, the Senate by this is basically saying that by Section 1 of the Legislative Houses and Privileges Act, civil or criminal proceedings shall not be filed against any member of the legislature over something that happened in the course of proceedings. So the Senate is basically saying here that what transpired on the day that the altercation erupted between Senator Natasha Akpoti Uduaghan and the Senate President are things that are taken under privileges that are covered and protected by the Legislative Houses Powers and Privileges Act. To the extent that whatever happened today, the law says you cannot go to court against a senator because the law has protected them to be able to give them the latitude and the freedom to be able to carry on their duties. So that is the essence of this ground too. And they are saying that the trial court ought to have recognized this provision of the law, okay, the Legislative Houses Powers and Privileges Act, to the extent that it had no jurisdiction to entertain a complaint that arose during the proceedings of the Senate, which is covered by the Legislative Houses Privileges Act. Ground number 3, the Senate is saying that the learned trial judge erred in law and occasioned a gross miscarriage of justice when his lordship held that the preliminary objection succeeded in part in that some aspects of the course of action may be inchoate, but in enforcement of fundamental rights, an act can lie where the infringement is anticipated. So the Senate is saying that the trial judge was in error to have taken this to be a fundamental rights complaint. The Senate is saying in the particulars of error here that the complaint had to do with privileges as a senator and not fundamental rights breach. And that if there is any fundamental right, it's ancillary. And therefore, that the trial court was in error to have entertained, the matter because the matter was premature. It had to do with the issue of, especially the issue of suspension. They are saying here that at the time that Senator Natasha Akpoti Uduaghan filed this matter in court, she was not suspended. She was invited to a committee. She did not appear. The committee did not submit its report. And therefore, that Natasha's suit was premature. I am not the one saying it. It is the notice of cross appeal of the Senate that has said it. And that is their ground number 3, right? So we get to ground number 4. What does it say? It says that the lower court erred in law when it assumed jurisdiction to hear and determine Natasha's matter, notwithstanding the fact that Natasha refused and failed to exhaust internal dispute mechanism embedded in the Senate standing orders. Now, in the particulars of error here, the notice of appeal is saying that by the rules of the Senate, internal disputes have to be resolved internally before a member can go to the court. That Natasha did not submit the dispute to the Senate for internal resolution before heading to the court. And therefore, they are saying that there is something called in law condition precedent, and that the condition precedent was not met, and therefore going to court without first of all exhausting the condition precedent was something that was done in error, and that the trial court ought to have said that and ought to have dismissed Natasha's suit based on the fact that it was something like jumping the gun, before and then going to the court. Ground number 5, that the learned trial judge erred in law and occasioned the gross miscarriage of justice when it held that Section 21 of the Legislative Houses Powers and Privileges Act does not apply to the first respondent, that's Senator Natasha, for the fact that she is a member of the National Assembly. What does that section say? It says that before you can go to court against a member of the National Assembly, you must present a complaint to the clerk of the National Assembly 3 months and allow 3 months to pass before you can head to the court. So they are saying that Natasha never did that and that it was a condition precedent that Section 21 of the Legislative Houses Act provides that a person who has a cause of action against the Legislative House shall serve a 3 months written notice to the office of the clerk. So that's saying that Natasha did not serve any such 3 months written notice to the clerk before heading to the court, and that's saying that it is in the Senate rules and it must be obeyed. Ground 6, that the learned trial judge erred in law and occasioned a gross miscarriage of justice when his lordship subsumed the determination of Natasha's application for interlocutory injunction with the originating summons on the grounds that the reliefs were both similar. So in the particulars, are saying that the Senate had filed a notice of preliminary objection that the judge should have determined that one first before determining the substantive matter, but that the judge decided to lump both together, saying that those reliefs were the same. The Senate is complaining about that also and asking the Court of Appeal to set aside the judgment of the court. Ground 7, the lower court erred in law and breached the Senate President's rights to fair hearing when it decided on its own and when it decided to raise and determine the issue of excessiveness of Senator Natasha's suspension. In the particulars of error, what they have basically said is that the issue of the duration of suspension was not part of Natasha's matter before the court. That as at the time Senator Natasha filed this matter, she was not suspended, and that there was no effort made to amend what she filed to accommodate the issue of suspension that came later, and that the trial judge had gone away from what was filed to talk about the issue of suspension. Because in law, it is said that everything must be pleaded. So there was no pleading on this, and therefore they are saying that the trial court ought to have restricted itself to what Natasha filed, and that if in the course of writing judgment there was need to raise the issue of the duration, the trial judge ought to have called everybody to come and address the court. And that once that was not done, it therefore means that the Senate President was denied fair hearing. And they are saying that the Court of Appeal should use that and set aside the decision of the Honorable Justice Binta Nyako. Now, the next ground of appeal, right, is ground number 8. What does it say? That the lower court erred in law when it made a recommendation with no basis in the questions and relief sought by the first respondent, Senator Natasha, in her originating summons, and held that the Senate has a power to, and I believe should recall the plaintiff and allow her to resume legislative duties. In the particulars of error, they have said that the court will not grant a relief which has not been sought. They are saying that Senator Natasha Akpoti never asked for recall, never asked for her to return in what she filed originally, and that there was no amendment to ask for that, and that the court is not supposed to be a Father Christmas to grant what was not sought, and that the court will not award more than what the plaintiff claimed. And that's saying that Senator Natasha did not claim recall in what she filed, and therefore the court had no jurisdiction to have exceeded what was filed to go into other issues. Ground number 9, the lower court erred in law when it proceeded to hear and determined Natasha's substantive suit, despite having found her to have violated earlier orders made by the court. Now, in the particulars here, the Senate is basically saying, the Senate through its lawyers, they're basically saying that the court had warned that no party should do anything on social media while the matter is pending. And that Senator Natasha Akpoti Uduaghan published the satirical publication that she made on her Facebook page, and that she did not deny it, and that the court was supposed to first of all reprimand her and then make her to purge herself of the contempt of the court. If fine was to be awarded, then she will pay the fine first before her substantive matter is to be heard, right? Lawyers will tell you that this is arguable. It is left for the lawyers on both sides to argue whether it was within the powers of the trial court to proceed with the matter and then make a final decision in the judgment, or to pause at the interlocutory stage and then make an order and ask for compliance before proceeding. But that's the ground of appeal that the Senate has filed in its own rights. And Natasha has also filed her own grounds of appeal. Ground number 10, the court below erred in law when it issued recommendations to the Senate on the amendment of orders and laws governing the internal procedure and affairs of the Senate, and expressed the belief on the steps the Senate should take regarding the recall of the first respondent. So under the particulars of error here, the Senate, through its lawyers, are basically saying that the court should have limited itself to adjudication of the disputes submitted to the court, that it was not the place of the court to make recommendations to the Senate for amendment of its rules, that by the doctrine of separation of powers, the court has no jurisdiction to make recommendations to the Senate regarding the internal affairs of the Senate, that by virtue of the Constitution, the Senate enjoys sole authority to regulate its proceedings, and that the court below was in error, and for that reason, the Court of Appeal should set aside that part of the pronouncement of the judgments of the court below. But others would tell you that, well, the courts presided over by very enlightened persons sometimes have the right to make a recommendation. It is left for you to take the recommendation or not. Okay? But it's left for both parties to argue it out. It can be argued either way. But that's a complaint that has been presented by the Senate before the Court of Appeal for adjudication to determine whether the trial judge had the right to make recommendations to the Senate. The last ground of appeal is ground 11, which says that the lower court erred in law when it swore to opined that the suspension of Senator Natasha by the respondent for 6 months was excessive, overreaching, and unconstitutional. And in the grounds of appeal here, they have said that that was not the business of the trial court, because that finding was not part of what Senator Natasha Akpoti Uduaghan claimed, and therefore that the lower court had no jurisdiction to have gone beyond what she claimed. So they have asked for reliefs. When you file a notice of appeal, you're complaining, you have raised the grounds, which is your complaint against the judgment of the trial court. What do you now want from the Court of Appeal or from the Supreme Court? So in this case, that's saying, one, an order of this court allowing the cross appeal and setting aside the part of the judgment that they are not comfortable with, an order of this court setting aside the part of the judgment of the court that they are not comfortable with, especially the issue of suspension for 6 months and the excessiveness that they have complained about, an order of the court striking out duplicated reliefs contained in the interlocutory injunction and also the ones contained in the mandatory injunction and originating summons, an order of the court invoking the powers of the Honorable Court in Section 15. Section 15 of the Court of Appeal allows the Court of Appeal to sit like a trial judge, a trial court, review the evidence, and then decide, especially the preliminary objection that was dismissed by the trial court. And that is all. They have asked for any other order that this court may deem fit in the justice of this case. So that is all what the Senate has filed against Senator Natasha Akpoti Uduaghan. And it's been signed by counsel to the Senate, plenty lawyers. You know, the Senate, they have a lot of money, so they can afford to, hire all these learned gentlemen, my colleagues, to enjoy the money but do the work for them. And finally, it is signed by one of the lawyers there representing all of them, Ogunwumi, Senior Advocate of Nigeria, Counsel for the Senate, Emmanuel House in Abuja. Address for service on Senator Natasha Akpoti has been stated here through her counsel, Sanusi Musa, Senior Advocate of Nigeria. So, Sanusi Musa and MJ Numa, I think it is MJ Numa, Senior Advocate of Nigeria, that wrote the letter that is currently circulating on social media. So that's the gist of what the Senate of the Federal Republic of Nigeria has presented at the Court of Appeal against Senator Natasha Akpoti Uduaghan. It is a cross appeal, which implies that an appeal has already been filed by Senator Natasha Akpoti Uduaghan. So it is now a case of two parties disagreeing against the same judgment, right? Nobody is satisfied with that judgment. No side is completely satisfied with the judgment. Both sides are disagreeing with the judgment. And that is why you have an appeal and you also have a cross appeal. Once I see the copy of the notice of appeal that has been filed by Senator Natasha Akpoti Uduaghan, trust me, I'm going to bring it up here also so that we see her areas of grievances. I wish both parties the best. I wish them luck in their appeals. And then I'm sure that Nigerian citizens want to see this matter decided as quickly as possible. It shouldn't be the usual kind of appeal that can last in court for 2 or 3 years, because what we're talking about here is something that also has to do with time. We want to see the Court of Appeal deciding this matter as soon as possible, so that Nigerians will also get to know exactly where the pendulum has finally tilted. Many thanks.